Hey guys, welcome to today's video. In this one, we're dealing with one of the most petulant, man-child defendants I've ever covered on the channel. This guy is currently in jail on a hold after picking up new charges while still on parole. He's a complete mess. First, he wants to fire his lawyer, then he wants to recuse the judge, then rehire the same lawyer only to fire him again. And if that's not enough, he's been threatening both the court and jail staff, and even decided to take his frustration out on a jail door with what can only be described as a mule kick. So, let's dive in.
This is Mr. Niegos. Are you able to see and hear me?
Yes, Judge.
This is case number 253691FY, the people of the state of Michigan versus Bobby Lee Du Bois. We were scheduled today for a preliminary examination. However, the court received some information regarding some security issues. One is it was relayed to the corrections officer that Mr. Du Bois threatened to punch the corrections officer. There was also a message that was intercepted by the corrections office through the communication system that was sent yesterday at approximately noon or 11:47 a.m. in which, from Mr. Du Bois' account, it says, listen, I don't care no more. Says don't watch what happens. I don't even come to court tomorrow because I'm going to flip out on this mother effer, and that is not what's said, but I'll clean it up. I'm going to show them a side they've never seen. If I could get within an inch of a guard or with that prosecutor, I'm going to effing choke the life out of her. Due to the security concerns, the court requested that corrections take certain precautions in which to bring Mr. Du Bois to the courthouse for his preliminary examination. However, the corrections officers could not do that because it's reported that Mr. Du Bois may have broken an ankle or a foot due to mule kicking a door. So the court finds for good cause, due to security purposes, we are not having the preliminary examination today. That will be adjourned to a later date. Also, it's now determined because a threat has been made against the prosecutor, whether or not a special prosecutor will need to be appointed in this case moving forward. So that is going to potentially delay this case. We will reschedule it for again next week to see where we're at. So
we've scheduled this 5 times already. That's why I'm in this situation.
Mr. Du Bois,
I've been patient with you, Your Honor. I have. We are 55 days into this.
For the record, I have muted Mr. Du Bois because he is interrupting the court proceedings. Counsel and I had that meeting in chambers before, and it was decided that this is how we were going to handle it. As I said, Ms. Carey is going to determine whether or not she needs a special prosecutor. Mr. Niegos, it's questionable as to whether or not he's the MFer that's referenced in the message as well. And it's my understanding he's going to make a determination as to whether or not he'll need to withdraw from the case also. Counsel, have I summarized what we've discussed and what's happened so far in this case? For the record, Mr. Du Bois has walked out of the security or out of the communications room.
Yes, sir.
You have, Your Honor, in the interest of efficiency and to alleviate some of the concerns that Mr. Du Bois started putting on the record, whether fair or otherwise, my plan was to have him briefly placed under oath and just inquire as to that simple fact. But I'm not sure that would be productive to do so today. I leave it to the court's discretion. But in terms of the court's question as to was that an accurate summary of what we discussed in chambers? It was.
All right. And for the record, Mr. Du Bois is back in the Polycom room. So for those reasons, the court does find good cause to adjourn today, and we will be back on a different date and see procedurally where we're at. We are adjourned. Thank you.
Thank you, Judge.
All right, that wraps up the first hearing. As the judge mentioned, there was supposed to be a proper hearing that day, but thanks to the defendant's behavior, nothing could actually get done, and it had to be rescheduled. What's funny, though, is that throughout both hearings, he keeps complaining about how long everything is taking while he's the one causing all the delays himself. Anyway, let's move on to the second hearing.
All right, court calls the people of the state of Michigan versus Bobby Lee Du Bois, case number 253691FY. Appearances counsel, starting with the prosecutor.
Joanna Carey for the people.
Good afternoon, Your Honor. Ryan Diego Superior on behalf of Brandon Du Bois.
And we are here for a preliminary examination on a possession of methamphetamine case and a resist and obstruct case. Mr. Niegos, I know you had mentioned some issues before we actually got the case called. Is there anything you'd like to address on the record?
Yes, Your Honor. I would just ask my client to confirm. We had a discussion yesterday. He indicated some concerns about a potential change or a request that the court recuse itself such that a different district court judge would hear this matter given the court's prior employment status. In my discussion with Mr. Du Bois yesterday, my conclusion was that it was insufficient to even make the request, but I would just ask for the court to ask of my client at this point in time, or allow me to ask him, basically, Bobby, do you want me to ask the court to recuse itself at this point in time, based on what you and I spoke about last night?
I do, and there's a couple other things that I would ask the court to hear me on before that as well. I'm not sure if the court is aware that there is an open investigation on the said officers that
Okay. No. We're not gonna do that. I'm on Zoom. We're not doing this. So if you believe that because Judge Wiggins was the prior Wexford County prosecutor and had worked in the prosecutor's office, are you asking me that I ask that he recuse himself, knowing that there's going to be a new judge that's going to be presiding, likely Judge Ransom, which is going to mean additional delays just to have this hearing done? You understand that?
I do.
Judge, based on my client's discussion yesterday, based on his representations today, understanding how clairvoyant and I guess that's not the right word, just how candid and transparent this court is in terms of its beliefs. I'm not sure ultimately, Mr. Du Bois is of the opinion that, he was previously prosecutor or attempts at prosecution were such when you were either the elected prosecutor or you were an assistant prosecutor. Based on his representations and his concerns on record today, and the fact that he's telling the court he understands this is going to be additional delay in proceeding to a preliminary exam, I would ask that the court graciously recuse itself, and I assume Judge Ransom would be the step-in judge.
I've got to hand it to this lawyer. He clearly doesn't want to be there right now, but he's still doing his job and making the best of a tough situation. That said, it's worth noting that most judges actually start their careers as lawyers. So, trying to find a judge who hasn't worked at some point as either a prosecutor or a public defender would be pretty difficult, if not outright impossible.
Well, I don't think there's anything specific in that request other than that you were the prior prosecutor, and I don't think that alone is enough for you to recuse yourself, and it sounds a little bit like judge shopping on the defendant's part, frankly. So I would ask the court to deny the motion.
Thank you. Defendant's request for me to recuse myself is denied. I do not believe I have a conflict in this case nor a reason to recuse myself. If the sole reason to recuse myself was because I have a defendant in front of me in which I was the prosecutor prior, I will say, other than maybe one judge, there's not a judge in this two-county area that would be able to hear the case. Additionally, I don't believe just because I was a prosecutor, both elected and a chief assistant, doesn't rise to the level of being recused. I will state before that I was a public defender. I will also state that while I am familiar with Mr. Du Bois' name, I can honestly say I do not remember one case that I prosecuted him on. So I don't believe we've risen to the level of a need to recuse myself.
Yes, Your Honor. Thank you.
Mr. Niegos, are you requesting to move forward then today with the preliminary examination?
Yes, Your Honor, please.
Any additional matters before we start?
I would just ask that the witnesses be sequestered.
Ms. Carey, do you have any witnesses? All right.
I don't.
I will order that any witnesses be sequestered. I will also state for the record, because we didn't do this before, Mr. Niegos appears by Zoom and Mr. Du Bois appears by Zoom from he appears by the Wexford County Jail. Due to some threats that were made last week, the court felt it best for court security purposes to conduct this hearing by Zoom. Ms. Carey, your first witness.
Thank you. The people called Deputy Shane Roloffs.
Your Honor, can me and my attorney have a moment in the breakout room, please?
Mr. Niegos, you want a moment?
Yes, Your Honor.
They're now stepping away for a moment to meet in a breakout room so the defendant can talk privately with his lawyer. However, according to the lawyer, the defendant ended up doing all the talking himself.
Mr. Niegos, have you had the opportunity to discuss matters with your client?
I have, Your Honor. I didn't get a full and complete opportunity to explain to my client what I'm about to say on the record because I didn't get a chance to speak. But essentially, my client's request is as follows. He wishes me to ask for an adjournment of this matter because he has initiated as he calls, an investigation into the actions of the primary troopers who investigated him in this event. He believes that the results of that investigation are paramount to his ability to present a defense in this case. He's also instructed me to subpoena some guards from the local Wexford County Jail for, at this point in time, I'm not sure what reason that would be towards a preliminary examination, but that's nonetheless his request. And the thing I didn't get a chance to tell him is to remind him that as this entire proceeding is now pending, he has no bond, he will have no bond, he's sitting on dead time, there's a parole hold on him, and whatever this MSP investigation that is or is not happening, he believes that it is. I have no information or knowledge of, nor do I believe it's paramount to my ability to effectively represent him in this case. That being said, my understanding is he wishes me that I ask for this adjournment, which I'm doing at his request against my advice. And I would ask that the court ask him directly if that is in fact the case, if he does in fact that this examination be adjourned once more, even though I'm here prepared to go forward today, despite his earlier complaints about how long it's taken to get all of this here. Thank you, Judge.
Mr. Du Bois, your attorney has placed on the record your request. Is that your request?
It's almost completely accurate. The part about an open investigation against Deputy Roloff and Deputy King for the initial stop is actually underway. I've dealt with state troopers in regarding to this matter. And I think that moving forward, I don't see how it could be anything that Deputy Roloff or Deputy King says until the end of that investigation. I don't think how it could be pertinent to what we have going on. And I would be more than willing to sit this dead time and deal with all the time that may occur up until now, until the resolution of that investigation is done, because there's going to be wrongdoing found, I believe.
So, Mr.
In regards to this,
what is the nature? And I don't want you to get into the facts of it, but what is the nature of your complaint to Michigan State Police?
It's not the Michigan State Police. It's Deputy Roloff and Deputy King of the Traverse County.
But you said that the state police were investigating it. So what was the nature of the complaint?
There was wrongdoing by Deputy Roloff and Deputy King.
Are you alleging
in regards to the drug, in regards to the possession? I'll say that.
Are you alleging that they're untruthful in some way?
Absolutely.
Mr. Niegos, do you want to follow up or supplement anything?
All right, let's hear from his lawyer and see if he's interested in joining in on the chaos that's about to unfold.
Absolutely not.
All right, Ms. Carey, any argument?
Can we have Ms. Chandler subpoenaed to court, please?
I'm a little bit perplexed. We've been here 4 times, and I know some of that has been on our part. I have the Grand Traverse County deputies here and ready. It is now almost 5 to 5 or 10 to 5. If the defendant wants to prolong this pending an investigation by the state police, that's up to him, I guess, and to the court. But just so he knows, it could be more than a week, and I don't want to have them come back for the 5th time next week. So if we're going to have it investigated, let's not schedule it until we're certain that investigation is over. then that's fine. Otherwise, we're prepared to move forward.
Well, it sounds like what Mr. Du Bois is asserting is some sort of Brady violation. And I will admit it's been a while since I looked into Brady, but as I recall, during other Brady issues I had, it's not necessarily appropriate to raise a Brady issue at the preliminary examination. It would be more appropriate for a trial, and that issue would be raised by trial. Presumably, if we were to move forward for preliminary examination, any investigation by MSP would be done by then. But even if there is some sort of investigation, that doesn't necessarily rise to the level that there be some sort of violation of either Brady or Giglio. So the court is prepared to deny that request today. But as Ms. Carey indicated, we are already at 5 minutes to 5, and I don't see how we can do a prelim today. But are you guys able?
I mean, I am.
The court and staff are willing to, if the party, Mr. Du Bois, it's my turn now.
Yes, sir.
If the parties are willing to hang over, we can at least get started on this and see where we wind up.
Your Honor, may I speak?
Mr. Du Bois, you have done more talking than any other defendant I have let talk in the last 3 months. Every time we come in, you complain that it wasn't moving fast enough, and now today has been nothing but stall tactics in order to get it stopped. You've had 3 months to file a complaint with Michigan State Police. They've had 3 months to investigate it. We're here for a preliminary examination today. I have to get this case moving. You can shake your head all you want. You can shake it all you want. But, you didn't have a prelim last week because of your own actions, and now you're asking for another an adjournment today.
That I did. That it was my fault. My child rights are being violated, and you're just letting it happen. That's why Ransom was going to throw it out the first time. What do you, I'm not being heard. You are, that's why I'm saying you're biased. You have tried me before in 23, 22. You come from the prosecutor's office. You and Joanna Carey are openly friends. How am I getting an unbiased fair chance here? Furthermore, I tried to fire this attorney already. I want to represent myself. Who knows my case better than I? Me.
That has to be one of the dumbest excuses I've ever heard for wanting to represent yourself. Don't get me wrong, it's not the first time I've heard someone say that, but it's like having a brain tumor and deciding to perform your own surgery just because you know your own thoughts and think you know what's best.
At this point, I would like to dismiss Mr. Niegos under the, I would like witnesses called at a prelim hearing. I believe I'm entitled to those, Your Honor. I believe I'm entitled to call my own witnesses. I believe I'm entitled to ask questions against, for the officers. None of this stuff. I feel like I'm just being pushed through, and I've been through this enough, Your Honor, that I know I got all the paperwork here that says what I'm entitled to. And yeah, I do talk a lot. You know why? Because I know what my rights are, and every time I don't, I get pushed through this system and I get screwed around. I do. And the investigation has started since day one. Since I come into this jail, I asked to speak with a state trooper. You can call them, get in touch with them. I encourage it because there's wrongdoing here.
Mr. Niegos?
I'm sorry, it's frustrating you. Imagine how I feel.
You're not frustrating me, Mr. I'm here all day, Mr. Niegos.
Your Honor, I obviously, I'm yammering and stammering. I'm not entirely sure what to say. He's representing. He knows his rights. He's representing. He tried to fire us before. I did have an opportunity to speak with him. I probably should have put this on the record as to the whole MFR thing in the note from last week. He indicated he was not referring to me or my firm. As such, I was going to continue with him based on his representations here today. I am absolutely more than fine to step aside. And since he indicates again that he knows his rights and etc., then if the court's inclined to discharge me, take zero offense or issue with that.
Has the attorney-client relationship broken down, do you believe?
I know that there's been a previous significant issue between he and a colleague of mine in my firm. The relationship between Mr. Du Bois and myself has not been a upward linear one, so to speak. And based on his representations here today, indicating that he's repeatedly, in his words, tried to fire me, as if indicating somehow I've insisted or I have some sort of vested interest to remain on this case as his counsel. I believe so, Judge.
What about the interview between us that was scheduled yesterday? You've missed two.
Okay,
Two
Mr.
times
Du Bois,
you're supposed to-
this is
you were
Mr. Du Bois.
perfect,
This is
man.
the perfect example. He's saying that the communication process is broken down. He wants out,
Oh.
and yet you want to argue with him. Why, I don't know, but you want to argue with him about
Because I
that.
want it on record why. I'm not just being disruptive. I'm stating what's going on. I should have an attorney that can come in here and sit down with me and go through my case, not 10 minutes before we come before you. This is the problem here. This is how it goes for every inmate that comes in here. If they're not paying for an attorney, they come in here, the lawyer sees them for 5 minutes, they don't go. How much time have you spent on my case?
Your argument might make a little more sense if you were the only criminal in need of a public defender. But here's the thing, if you can't afford the lawyer of your choice, maybe it's time to rethink your antisocial and criminal behavior instead of blaming the system for your own actions.
Tell me some specifics in it, Your Honor. Nobody can. That's why I'm raising such a fit about this. It's unconstitutional. You tell me that I'm getting a good defense by one of these lawyers that spend no time. He's on Polycam. We have not sat down one time and went over any part of my case. Not one. You tell me how that's constitutionally right and fair to my fair and speedy trial. Am I right to be represented by a decent attorney? I don't
Well, Mr. Du Bois-
understand why you guys can't see what I see and what other people see. I don't get it. I'm not trying to waste time. I'm not trying to be disruptive. And you know what? I take full accountability for my actions, why I'm in these chains, and
No,
why
I wouldn't say that. I wouldn't be saying anything about accountability or why you're in those chains before you fire me formally. Don't say that.
I want an attorney that will come here, sit down
All right,
with me
Mr.
and
Du
go
Bois,
over my case.
let me ask you a
Or
question.
I can,
Mr. Du Bois, let me ask you a question.
yes,
Do you
sir.
want an attorney or do you want to represent yourself? Because you've said two different things now.
I want an attorney that will come here and that will go over my case and give me the time and respect that I get.
I have no control, Mr. Du Bois, I have no control over who the public defenders appoint. I have no control over how they conduct their interviews. I have no control over that. All that has been removed from the court back during the reforms that started the Indigent Defense Commission. I have no control over that. All I can do is, it sounds like, based on what Mr. Niegos has told me and what you've told me, all I can do is order that Mr. Niegos is removed from the case because there's been a breakdown of the attorney-client privilege. You might get Perry Mason next time, or you might get Barney Fife. I can't say who you're going to get next time. But I do not have an endless supply of attorneys. Do you understand that?
I do understand that, and I don't, am I not entitled to a good defense? Am I not? 5 minutes
You are
before
entitled to
we
a good
come
defense,
before
but
you, Mr. Wiggins. Go ahead, sir. I don't want to interrupt.
Thank you. You're doing a very interesting job of not showing that. As I said, I have no control over who is going to be appointed to you. And yes, you do have the right to counsel, but you also have the right to hire your own counsel if you are not happy with the counsel you're receiving. And where you're indigent, which is what you are, I can't just go start knocking on doors and saying, please represent this person. There are attorneys that are under contract and under hire with the Wexford Missaukee Public Defender's Office. I have no control over that. So I'm willing to release Mr. Niegos It sounds like he's in favor of that. It sounds like you're in favor of that. But I have no control over who you're going to get next.
But
I want to make sure you're clear.
have control over how they conduct what had like 5 minutes to go over. We haven't went over anything in my case. Nothing. Don't you have? Can you point me in the direction of who to complain to? It's not my fault. I'm indigent. Like.
I completely agree.
Who can I complain to so I can get proper and adequate representation?
I seriously doubt that your definition of adequate matches the court's definition of it. In fact, I'd be willing to bet that your version of adequate comes with a $200 an hour price tag.
Mr. Du Bois, if you would give me 5 seconds, can you do that for me?
Absolutely.
You can contact the public defender's office here. They can direct you in a way to make a complaint. As I said, this is not the old days where the court had control over the public defenders. I don't do that. I have no control over who gets appointed, the directions they take a case. That has been entirely removed from the court. That's between you, the state of Michigan, and the Public Defender Indigent Defense Commission. But based on what I'm hearing today, I will remove Mr. Niegos from this case. We will make another referral to the Public Defender's office for the appointment of an attorney. We'll get everybody back here, but I'm not going to set it for next week. I'm going to put this off until it's going to be, and I'm not going to reset it for a probable cause conference. This case has gone on long enough. It's going to go right back to the preliminary examination. So because of that, I'm going to set it out a little bit longer. We'll go out at least 2 weeks. In the what?
28th of October.
The 28th of October. If the parties can agree and the court finds there's reasonable grounds to put this back on for a preliminary or a probable cause conference, I'll consider it. But it's going to go on the docket as a preliminary examination. Nor can I even guarantee that by the 28th you'll have an attorney. I had another case today that's been almost 2 weeks, if I recall correctly, that they're still waiting for an attorney to take the case. So just so you're aware of all.
Can I represent myself until then?
I need to be convinced that you are able to represent yourself. Yes, you have a constitutional right to represent yourself, but that's not an all-encompassing right. The court has to be, and you can let the jail go as well. The court has to be convinced that that is a knowing and voluntary waiver of your right to an attorney, and that you have the wherewithal to represent yourself. So before I go ahead and do that, we have a process we're going to have to go through. But I want to be very clear. Are you asking to represent yourself, or are you asking to have court counsel appointed or indigent defense counsel appointed?
I'm asking to be able to have the resources to represent myself and look into my case law, and reference those things until an attorney is appointed so I can better represent myself.
If you're asking the court to appoint you a lawyer, then you're not representing yourself. And if you decide to represent yourself, the court isn't going to assign you a lawyer to do all the work while you sit back and binge watch Perry Mason as your version of legal training.
Well, but see, therein lies the problem, because you can't represent yourself in between time of an attorney being appointed. If you've requested the appointment of an attorney, the attorneys can't talk to you, and I can't talk to you in very limited circumstances until you have an attorney appointed. So that's why this question is very clear. Are you requesting the appointment of an attorney, or are you wanting to represent yourself? You can't have it both ways, just so you're clear on that.
So I can't be granted access to a good legal law library so I can actively participate in my case until I have.
You can do your own. You can have access to the law materials, but because you've requested a court-appointed attorney, you can't make any filings with the court, and you can't have any communication with the court or the prosecutor's office, except in very limited circumstances.
Okay. Yeah.
Does that make sense?
Like to try to get an attorney, a public defender that I can work with and that will come here, and to save time for you in the court, all I'm asking for is an attorney to come in, review my case with me, take an interest in my case So I feel like I'm adequately represented, because at this point, I don't feel like I have been. You can't adequately represent somebody 5 minutes before they go into court, Mr. Wiggins. That's been my whole thing. That's been my whole case. That's why I'm frustrated. That's why I'm an animated person by nature. Anybody will tell you that. The people at the jail, anybody that knows me, I'm animated by nature. I don't mean disrespect by it. And yes, I do get on a rant sometimes, and I am long-winded, but that's because I suffer from disabilities.
Nah, what you're really suffering from is a bad case of can't shut up-itis. But don't worry, a little time in Prisonium might just be the cure for that.
That's just what it is, and I'm sorry that you feel like I've wasted your time, but this is important. This is my life.
You're not wasting my time. As I said, I'm here all day, 5 days a week. But now, Mr. Niegos, I've released you, so if you want to go, you're more than welcome to do that.
Normally, Judge, and I do apologize to your staff, especially since the time. Normally, I don't respond to these kind of comments because he's not the first nor the last that says these things. But in this case, given the documentation we have in our file and the comments he made, I just would like to put on the record that we've attempted multiple, albeit remote, jail visits. The first one was conducted with my legal and with my research and writing specialist, who does all of our
when they didn't show up. When they didn't show up, it's documented.
Mr. Du Bois, you had your time. Now it's Mr. Niegos' time. You made all kinds of accusations against him. Now it's his turn to defend himself.
Yes, sir.
So the first attempt for a virtual visit, which is always the initial visit that we handle to go over the police reports and the initial things, happened on October 13. The notes in the file. This was also a case that I accepted on short notice. It actually occurred on October 2nd. I apologize. And the notes in the file indicate that essentially the visit was conducted and was terminated due to Mr. Du Bois essentially not liking what he heard in terms of what potential defenses and such he may have had. Another visit was then scheduled for yesterday that Mr. Du Bois is referencing. He and I spoke on the phone last week. The sole purpose of that visit was to discuss the note from last week and whether or not I would stay on as counsel for him. And during our phone call last week, he and I agreed, or I agreed at his request, to stay on. And finally, the last point, Judge, in terms of what we did or didn't do, as he can at least attest to this, he's got copies of his police reports. This is a preliminary examination. I spoke with him. The anticipated outcome of the preliminary examination and the anticipated motions we'd be seeking to file in court. The bottom line is this, Judge. This is an individual who knows the laws and knows his rights after he allegedly committed crimes. And at this point in time, it's, of course, his defense attorney's fault for him not adequately being represented. I was ready to conduct this preliminary examination. I've explained to him the motions that I anticipated filing based on my assessment of the case that would have led to a bind over, given the evidence in this case. He doesn't like what I had to say. I respect his wishes. I wish him nothing but the best. But in terms of the representation, and it's not just me. I have people that are very helpful, that work very hard in our firm, who try to do the things that we do. And a lot of what we do is service communities like Wexford, communities like Misaki, communities like Sheboygan, places in northern Michigan as well as southern Michigan, where frankly there are not many standard 7 qualified attorneys to handle capital life felonies. My firm does an abundant amount of appointed cases by choice, not by need. And I wish Mr. Du Bois all the best with whoever other public defender or conflict attorney on the roster accepts his case. Thank you for allowing me to put that on the record.
That was his very professional way of saying, "You can back off my team and I know exactly what we're doing." They deal with people like him every single day. And honestly, if he thinks he can do a better job representing himself in a felony case that carries a life sentence, then good luck to him. But let's be real, that lawyer won't be losing any sleep when the defendant inevitably doesn't win.
Thank you. Now, Mr. Du Bois, you raised another issue, and that is a friendship between Ms. Carey and myself. And yes, well, Ms. Carey and I had worked together for a number of years. She was also my chief assistant prosecutor while I was the prosecutor. And yes, we did have a friendly relationship. But I will state, since becoming judge, I don't want to say that friendship has ended, but as far as Ms. Carey and I doing anything together, That has not happened at all since I was judge. The most time we spent together was a couple weeks ago at a conference with 4 other persons, including Mr. Champion, the chief public defender, and the community corrections director. So as far as your allegations that I can't be impartial because of a friendship that I have with the prosecutor, I don't find that persuasive. I've ruled against Ms. Carey in a number of cases as the judge, and I've ruled in favor as the judge. I've also ruled, in favor against all the other prosecutors. We're in a small community, and unfortunately, that's how small communities work. But I have the ability to separate myself from any friendship that I have with somebody to make sure that justice is carried out. And if you aren't feeling that that's being done, I apologize for that. But that's simply how it is. But you can certainly raise these issues with your next attorney once they get appointed. And if you feel, and that attorney feels there's need to go ahead and file a motion to recuse myself, I'll certainly hear that motion again.
I have one now. I've written it myself. I tried to follow
But
the
Mr.
right.
Boyes, you've requested the appointment of an attorney, so the court can't hear that motion.
Well, but I asked him to do that before this, and did
Okay,
you see the
but
problem that we keep running into?
But again, that's water under the bridge. I'm just telling you, moving forward, you can discuss that
Okay.
issue with your next appointed attorney. All right?
Okay. Yes, sir.
Okay, we are adjourned.
Alright, guys, that's the end of the video. What do you think the chances are that he fires his next attorney too and ends up representing himself again? If you enjoyed the video, make sure to hit the like button, and if you didn't, go ahead and hit the dislike. Don't forget to leave a comment below, subscribe with notifications on so you never miss any of my content. This is Truth Pulse, and I'll see you in the next one.